This meeting of the Littleton Licensing Authority will come to order. Will the city clerk please call the roll?
Authority Member Bradish.
Here.
Authority Member Cole.
Here.
Authority Member Levere.
Here.
Authority Member Mather.
Here.
Authority Member Odell.
Here.
Authority Member Peterson. Authority Member Webb.
Here.
That makes a quorum. We have 5 voting members and 1 non-voting alternate today. Next item of business is the approval of this agenda. I'll speed through that because there's only one item on the agenda, and that's item 10A, which is a show cause hearing. Do I have a motion to approve the agenda?
I'll move we approve the agenda.
I'll second.
All in favor?
Aye.
Aye.
Next item, approval of the certification of minutes. We don't have a copy of the minutes, but I would make a motion that we approve the certification.
I will so move.
Has there been a certification?
Yeah, I think let's just table that. I don't see any minutes attached, and so she didn't do the certification. So let's not do that agenda item. And if you need to do it, we'll just add it to your next meeting, and you can approve them then.
Okay, well, it says approval of the certification, so.
Yeah, I don't see anything attached though, and she's not here, so.
We will proceed then to our major item of business this evening, 10A, show cause hearing, Vasilios Rangenkakis, doing business as Old Mill Brewery, 5798 South Rapp Street. I believe we have comments from the prosecutor, or do we have to accept the exhibits first?
Well, I think you have 2 motions in front of you that you should hear and decide on before we.
Should we do that before the exhibits?
Before we get into
All right.
the case.
Thank you.
Those would be my motions whenever you're ready to proceed. Did I enter my appearance?
Would you step up to the?
Here.
Thank you. Would you state your name, please?
Good evening. My name is Peter Menges. I am an attorney. I am the attorney for the Old Mill Brewery.
Thank you.
Should I state my motions and my business
Yes,
before
please.
the board? Your Honor, I was recently retained on this case. I did file an entry of appearance. I also filed a motion to continue this hearing. And I would add to that motion that when I was when I filed the motion to continue, I was told I would get a file and exhibits and so forth. I've received nothing from Littleton concerning this case whatsoever. Even if I had received it, given the short time that I had all this discovery, which I anticipate will be voluminous, I've also been in the process of obtaining my own records. I've gotten some records. I'm still waiting on some records. We've conducted an investigation both to the substantive case as well as mitigation issues. My investigator was just here. We've interviewed a couple witnesses. We don't even know who their witnesses are. The prosecutor told me that she anticipates calling 18 witnesses. So this is going to be a pretty protracted hearing. The discovery is going to be voluminous. I don't even have their discovery at all. I'm still obtaining my discovery. Once we obtain that discovery, we're going to do a thorough investigation. Their 18 witnesses, we anticipate double or triple that on our side between substantive offenses and mitigation. I just don't believe I've been afforded adequate time to prepare for this hearing. I'm very efficient. I'm not asking for a lot of time. I'm thinking approximately 60 days we'll be ready for a full hearing.
Does the city have a response to the motion?
Yes, the city would object to the authority granting the motion to continue. First of all, this incident occurred on November 5th. The probable cause hearing was heard in December. The licensee was given the proper notice as evidenced by the exhibits that are in front of the authority this evening. And then the show cause hearing was set for tonight. My argument is there's been 3 months since the incident. If the licensee wants to argue that he didn't really have notice until the probable cause hearing, I would argue that there's still been 2 months since the probable cause hearing in order to prepare for this. I spoke with Mr. Menges last week, I believe, he indicated that he'd be entering. I instructed him to get his entries, his motion to continue in as soon as possible, and to get the request for discovery. At least 5 days later, I received the entry of appearance and the motion to continue the hearing. I never received a request for discovery, but despite that, I had the clerk, Ms. Norton, prepare the discovery and mail it to Mr. Menges. She right now is printing all the documents that we have within our possession. I would argue also that those documents were also given to the licensee when we gave him notice. So the police report is essentially the main part of the discovery, and that was furnished to him by Ms. Norton when notice was given. At this point, I think it's fairly consistent that the board does allow 30 days from the probable cause to the show cause hearing, and I'd ask the board to stick with that and deny the motion to continue.
May I respond? I spoke with Ms. McCarthy for the first time on this case on January 5th. She told me to go ahead and file an entry of appearance in the motion to continue, and she would forthwith provide me with the discovery on the case. So I filed this motion the next day. I never received any discovery till this day. Now I still haven't received it.
Mr. Menges, is there any reason that your client didn't obtain counsel until essentially last week?
Well, a little bit more than last week. Your Honor, I actually met with them prior, but I had to do some investigation. It was the holidays. I was out of town. So by the time I was formally retained and met my clients, I started working as diligently as possible in the circumstances. Met with them on the 5th, met my clients at their establishment, started investigating the case, spoke with Ms. McCarthy, entered my appearance, filed a motion to continue, requested discovery, started obtaining records on my own, started interviewing witnesses with my investigator, and we're just not there yet. And I don't see how we can have a hearing when I still, now that we're at a hearing, have not received any discovery from the prosecutor at all.
I understand that. I know that you have, your duty as an attorney, but was there any indication as to why they waited until, I understand the holidays, but again, this incident happened in November. We were here at a meeting, at a hearing in December. Did you have any indication as to why no action was taken until January?
That would be privileged if I did.
Okay.
Mr. Menges, the city anticipates calling anywhere from 8 to 24 witnesses. If you were granted any continuance, how many witnesses did you think you would call in rebuttal to the city's testimony?
Well, Your Honor, there's a couple issues there. Once I know who the 8 to 24 witnesses are, some of them might be the same witnesses that I would call. I've interviewed probably 4 witnesses today, 3 or 4 witnesses today that I anticipate that are under the city subpoena that I would also call. I would anticipate many more than that in any event for the substantive offense, but then if we do get to a mitigation phase, I anticipate a large number of witnesses. Best guess is 20. And these would be short witnesses for mitigation. I don't know how much cross-examination, but I certainly need to secure their attendance, figure out what they're going to say, and have them present for the board. Excuse my voice.
Happens to all of us. Go ahead.
I would also like to point out to the authority that we do have a criminal case going on at this point, and I don't have that file in front of me, but an attorney for that case was hired almost immediately. I think I met with that attorney on December 10th. So there's been a lot of notice that has been given to the parties, and the city's having a problem with hiring a criminal attorney almost immediately, but not getting an attorney on board for the licensee when adequate notice was given. I would also like to point out that I do have 2 witnesses that are going to be available tonight via Skype from another state, and as you can see behind me, I have 8 officers that are here in order to testify.
I do not represent the employee in the criminal matter.
Any discussion from the authority members?
Just a point of clarification. Madam Prosecutor, as I'm finding a fact, can you tell us the status of the criminal prosecution?
The criminal case is pending. I met with the attorney for the first time on or about December 10th. I'm meeting with her again, I believe, February 2nd for a pretrial conference. The status on December 10th is that she had just been hired, had not gotten discovery. Since then, she got that. I believe she got that within about 5 days of me seeing her on the 10th. And we will see her back again on February 2nd to discuss possible plea resolution.
Thank you.
Whom is the target of the criminal prosecution, the defendant?
The defendant is Peter Fraginkakis.
And is Peter in any way on the license? Is he the licensee for the establishment?
Peter is the son of the licensee.
But Peter does not have any ownership?
No,
In
he's
the
no
li-
longer an
okay.
employee. He has no ownership. The licensee is a corporation, not an individual, but the main member of the LLC is the, excuse me?
It's individual.
Oh, it is an individual now? Oh, I'm sorry, it is a DBA. The last license was an LLC, so it is a DBA. So it's the father of the son, who is just an employee, no ownership interest, no longer employee from that date till now.
Mr. Chairman, may we ask for some guidance from the city attorney? Madam City Attorney, are we allowed to take testimony tonight and then postpone the hearing and allow the defendant to then present their case and resolve it at a second hearing?
Yes, that certainly is within your authority tonight to make that decision.
Mr. Chairman, based on that, I would make a motion that we elicit the testimony from the witnesses present tonight for as long as it takes, and then recess the hearing to a date certain within 30 days and receive the testimony from the defendant, the licensee, and at that point to continue the hearing.
So basically, your motion is to reject the motion to continue.
Excuse me, if I can interrupt, you're an alternate tonight, so I need one of the voting members to make a motion.
We discussed that earlier, and I thought he's allowed to make motions. He's just not able to vote.
No.
Mr. Mingus, would you be opposed to taking testimony from some of the people who are here who've been subpoenaed tonight and allowing another date in the future when you would be able to put on your case?
I would. I believe that's a violation of due process. I still don't have discovery. I don't know who these people are. I wasn't provided any discovery. I wasn't provided any witness lists. I still don't even know who these witnesses are they're asking to call tonight. I think this is my client's livelihood. I think he's entitled to due process and a fair hearing. I don't think we can get that unless I'm at least provided the most minimum discovery in this case prior to the commencement of the hearing.
Are we discussing?
Do we have a motion?
Just my initial thoughts on this. We generally go from a probable cause hearing to a preliminary hearing, then to the show cause hearing. We, in this case, skipped over the preliminary hearing because we were told there would be no stipulation offered or negotiated, and we skipped that. But another part that kind of goes into those preliminary hearings was making motions, this kind of motion, to ensure that everyone's on board, the council's been retained, that everyone's prepared. And I feel maybe we skipped over that part. So I would make a motion to accept the continuance and set a date in the future.
Do we have a second? We don't have a second. That means the motion fails. Do we have another motion regarding the motion to continue?
Counsel, I'd like to ask you again.
Sir?
Is it your feeling, as I understand it, that with the notice as described by the attorney for the city prosecuting this case, that if you hear the witnesses in the case by the prosecutor and you are given another 30 additional days after hearing this, you do not think that you've had adequate time to prepare a case for the licensee and get due process?
That is my position, sir, and that position might be different today if Ms. McCarthy actually sent me the discovery as she promised me on that date. She didn't.
And I would adamantly object to that statement. I instructed the attorney to file an entry of appearance, file a motion to continue, and file a motion for discovery. Basically, what I was asking him to do was to do his job. I did not make any promises to do his job for him. When I received the motion to continue that was faxed to the courthouse and not properly to the clerk for the city, I forwarded that on to the clerk for the city, and I instructed her to prepare the motion or the discovery packet. As you can read in the motion to continue, there is no request for discovery. That is very common and basic for most attorneys, is to request discovery, enter their appearance. I made no promises. In addition to that, that information has been available on the website for at least the past week, as well as that information was forwarded to the licensee at the time of the probable cause hearing by Ms. Norton. This information has been available. In addition, that information was given to Mr. Fragenkakis, Peter, his attorney. This information is available, and despite what they want to say about Peter's no longer an employee, he is still the son of the licensee. Mr. Vasilios Fragenkakis has appeared at every portion of the criminal pretrial conferences. He's fully aware of what is going on. They had the information.
That is a misstatement of fact and a misstatement of law. The misstatement of fact is Ms. McCarthy, during our conversation, quoting from my notes, said, file an entry of appearance and discovery will be automatic. To say that it's normal in these kind of cases, these kind of cases are quasi-criminal. Rule 16 specifically forbids requesting discovery because it acts as an operation of law. The prosecution is required to provide discovery without motion and without request. That's what I was told that was done here. That was not done.
My response would be to ask the city attorney, because the city attorney is the counsel for this authority, and we depend upon our counsel for interpretation of legal facts in law, since we are not attorneys. What is your opinion of what you have heard from both the prosecutor and the attorney for the licensee?
Well, it's up to you to weigh which story is which story you want to give them.
I'm not so concerned, because you can obviously not, and we cannot sort out when he said it is not fact what was done. We were not present. But he has made reference to law, and he says this is in fact not the law. So I'm not asking your advice on what is fact and not fact is what people have done, but in law, he said that the prosecutor's interpretation of the law was, in fact, incorrect. You may not have opinion. Do you have any opinion to whether one opinion, the opinion I heard from the prosecutor, or the opinion in law that I heard from the counsel for the licensee is accurate?
I guess I'm unclear what the point of law is that they're disagreeing as to.
Could you explain that one more time to her?
Sure. Once I enter an appearance in a hearing in any jurisdiction, in any forum, the other side is required to give me discovery. If we go forward, when I still don't have discovery in this hearing, I've been practicing full-time since 1997. I practice in almost every jurisdiction in the state, the federal, District of Colorado, the Supreme Court of the United States, liquor boards, administrative hearings. This would be the first. You'd be the first people to ever let a hearing proceed without the most basic, fundamental due process right of simple discovery. And that's under Rule 16 in the criminal rules. I know it's in the Littleton Code. I don't have the citation for the court, for the board, but it is there.
Then I need to ask you, is it, as the prosecutor has told us, in fact, that she issued you certain instructions that should be part of an attorney's due diligence on behalf of the licensee, and she asked you to perform those duties Did you or did you not?
Well, first of all, she told me I didn't have to request discovery, it would just come. But as a matter of law, that's how it works in every single case, in every single jurisdiction. You don't ask for discovery. The person that's bringing the charges provides discovery as a matter of law. Discovery was never provided by a matter of law. She violated the law. I'm not asking for sanctions, I'm asking for time. Simple time.
So neither you nor your client have seen any of the exhibits that we have here in front of us?
I don't know what those exhibits are you have in front of us, because I haven't still not privy to them.
Okay.
Have you
either
seen any exhibits?
I have
provided
not
by-
seen any
Have
exhibits.
you or your client, has your client seen any exhibits?
We don't know what the exhibits are.
Has your client seen police records from that evening?
We have both seen some police records.
Well, I passed on the previous motion, but I'm more inclined to go that route. I'm unimpressed that this is where we are and that it looks like we may have wasted people's time here tonight. But at the same time, it looks to me like the counsel for the client, would make a case of this. He's here in front of us telling us that he doesn't have the discovery that he needs. I think it's an unfortunate position that we're in, but I'm more inclined to support a delay.
I am also, for the simple reason that I am not able to sort this all out in my own mind to my own satisfaction. What I do not want to see is that this authority takes a position that will lead us to an appeal that costs the city undue time and financial burden. I would assume if counsel is resolute in this, he would appeal. At the same time, I find counsel's position unreasonable to not agree to let the authority hear the witnesses in the case of the prosecution at this point, because then you have time. You've seen the case. It's better than if you'd got the discovery and were coming in here. You've seen the prosecution's case, and you have that month to do all this discovery and come back. And with the time and effort that's been put in to the gathering of the witnesses and what has been done, I would tell you my preference is I feel a lot better if you were agreeable to the prosecution putting on its case and then having that time, then knowing what that case is, to do your discovery and come back. I'd feel a lot more comfortable with that. But as I understand it, you are not.
That is not how the legal system works, sir. And I would, and of course, if a denial of a continuance would lead to an immediate appeal, to answer your question.
Okay.
Substantive due process, procedural due process, constitutional law 101.
And just for the record, I think what has been clear tonight is he was hired sometime in December. He, from his own statements, called me on January 5th. If you look at Exhibit K, which is the motion to continue, that was sent to my office and received on January 8th. So 3 days after I talked to him on the phone, which was a Thursday, I immediately on that day forwarded it to Ms. Norton. Ms. Norton compiled the discovery and sent it in the mail to him.
That is, again, an incorrect statement. As you see this from the certificate of service, the phone call with Ms. McCarthy was on the 5th. These motions were both filed on January 6th, certified by Erica Gutierrez, my receptionist. No discovery was ever sent or received as I stand here right now.
And if you look at the certificate of service, it was mailed to my courthouse on January 6th. I received it on January 8th, 3 days after the phone conversation. Once again, it was sent to the courthouse and not sent to the court or the clerk of the city.
It was sent to both, sent to all those parties.
My opinion, I'm not persuaded that there's a necessity for this continuation. I think we can go ahead hearing the prosecution present their witnesses. Subsequent extension of this hearing can be done. You can present your witnesses at that time. I'm not a lawyer. I'm not going to comment on the legality. I'm looking at what is best to move this thing forward, and that's my opinion. So the authority will have to make a motion up or down on this motion, and I'm asking for that motion at this time. Do we have a motion?
I would make a motion that we delay until the regularly scheduled February meeting. Should give approximately 30 days.
I would second that motion.
So we have a motion to continue the case until the regular February meeting. Is that my understanding? Any further discussion on the motion before we vote?
Before we vote, I'm assuming that this will take more, it sounds to me like this is going to take more than a 3-hour time period. Would it be good to have a follow-up motion to schedule more than one time period for that, or would that need to be included in this?
Yeah, let's go ahead and see if we get this motion passed, and then we can go ahead and see if we need to schedule some special meetings
I agree with
to
that.
get through this amount of testimony.
Once we have a decision on the motion, then we can talk about how to proceed from
Okay.
there.
So my discussion is just, again, I'm frustrated by the situation we're in. I can certainly understand the prosecuting attorney's frustration, but the fact that the licensee's counsel is standing here telling us that he hasn't seen the discovery makes clear to me that we need to give the opportunity so that this doesn't become an issue of process rather than substance.
Are we ready to vote? Would you please poll the authority?
Authority Member Bradish?
No.
Authority Member Cole?
Yes.
Authority Member Levere?
Yes.
Authority Member Mather?
No.
Authority Member Odell?
No.
That's 3-2. The motion does not pass. We will proceed with the hearing this evening.
Do we, though, need to make a formal motion? I mean, our motion to delay did not pass, but
Right, so I guess I'd like to know if there's a motion to perhaps delay for a time less than 30 days, if we wanted to schedule a special meeting in perhaps 2 weeks. I know we had talked about doing 2-week special meetings.
Before we go,
I will say, as I've heard, I think that the licensee does intend to appeal. If we do not grant some time, I'm not sure that it's a winnable appeal, but it obviously is a concern for the city to have to handle an appeal. And if there's a shorter amount of time that might be acceptable to the authority, I'd ask that you consider that.
But that's what the motion was.
The motion was for a 30-day continuance.
Motion was for a 60-day continuance, but I would
Oh,
accept.
sorry, his motion was for a 60-day continuance. Authority Member Cole's motion was for a 30-day
Yes.
continuance.
Did you just say you would accept a 2-week?
I'll accept a 2-week.
All right, I'll move that we delay 2 weeks or the date of,
I think we looked at January 28th. Is that a Wednesday?
yes.
And that is
All right,
clear
I'll-
on the council
I'll move
calendar.
that we delay until January 28th, at which point we would move forward with the show cause hearing.
Would that give enough time to do subpoenas, get witnesses back on track?
Yes, all my witnesses from the city are here. We do have Katie Cashman and Jonathan Cavalier. I would just ask the authority, they're seated over here, to basically order them to return on the 28th in lieu of me issuing subpoenas again, basically in order continuing their subpoena. And I do have those subpoenas if you'd like to review them. And then all my other witnesses should not be an issue.
Then I will second Chairman Cole, or Authority Member Cole's motion.
City Attorney has a question.
Does that work for you, Mr. Mendez? Are you available that evening?
28th, what time, ma'am?
That would be my next question. If the authority wanted to
Two-week continuance, is that acceptable to you, sir?
If the authority would like to consider an amendment to that motion to perhaps start at an earlier time that evening, is another possibility. It's a special meeting, so you can schedule
why don't,
Mm-hmm.
why don't we move forward with the motion on the date, and then could we, I think it'd be helpful to discuss then the time that meeting would begin, and then also any other scheduled times that we would need to do. I think it'd be helpful if we could put those on the calendar.
Okay.
So if the authority is okay with it, why don't we, or if following any further discussion, vote on the date, and then discuss whether folks could be here any earlier, would desire to be here any earlier that night.
I think we're ready for a vote. Would you poll the authority, please?
Authority Member Bradish?
Yes.
Authority Member Cole?
Yes.
Authority Member Levere?
Yes.
Authority Member Mather?
Yes.
Authority Member Odell?
Yes.
The motion is carried. We will continue until the January 28th meeting. I think we should discuss starting at an earlier hour. One of the questions is the availability of this chamber that evening and at an earlier time. Does anyone know the answer to that?
We believe it is available.
It's available?
I could be available earlier, certainly by 6.
I can be here by 6.
I as well.
I'm fine with that.
Mr. Mangus, would you
I'll
be
make myself
available by 6?
I'll make myself available at 6.
I think we probably should make a motion to that effect, which I will so move. Do we have a second?
Second.
Would you poll the authority, please?
Authority Member Bradish?
Yes.
Authority Member Cole?
Yes.
Authority Member Levere?
Yes.
Authority Member Mather?
Yes.
Authority Member Odell?
Yes.
Do we, oh, sorry, Mr. Chair.
I was just going to say, at this time, I would like to thank the members of the police department that generously gave of your time to be here this evening. We have to ask you to come back one more time in 2 weeks. We just have no choice, and I apologize for the misuse of your time this evening. Thank you very much for being here.
Do we need a formal motion or order on the return of our subpoenaed individuals?
Sure, let's go ahead and do that.
So would the proper motion be everyone who is here present tonight, or everyone who was subpoenaed to be here tonight? Or both? Everyone who was subpoenaed and is here tonight?
Yes.
Okay. I'll make a motion that each individual that was subpoenaed and is present here tonight return on January 28th at 6 p.m.
I'll second that.
City Clerk?
Authority Member Bradish?
Yes.
Authority Member Cole?
Yes.
Authority Member Levere?
Yes.
Authority Member Mather?
Yes.
Authority Member Odell?
Yes.
That motion is carried.
And I would assume this goes without saying, but that the items, did I hear the items are now, we have items that we could hand to Mr. Mangus tonight?
They were just tendered to me, sir.
Okay, so you've received them tonight?
Receipt of them
Okay.
on the record here before you.
And
Thank you for your time.
For the record, so there's no confusion, we have handed him the entire, basically the entire packet that was furnished to the authority. all the exhibits that are in the agenda. We are now handing him the set of photographs and the 911 tape, as well as all the witness statements that were furnished by the police department.
Is there any use for entering these exhibits tonight so that we can be referring to them by exhibits, or should that just happen at a later time? Does it matter? I only ask because, like, when we said you have Exhibit F, would it be helpful to be referring to it?
We haven't entered the exhibits yet, but they are the exhibits that are attached to the council communication.
And what I'm saying is, would it be helpful to the ones that we have, would it be helpful to enter those into the record tonight, or should we do that at the 28th?
We could go ahead and enter them this evening, and then we can let the record reflect that we've provided exhibits A through K.
So I would move that we enter exhibits A through K.
As well as the photographs taken by the police department, as well as the 911 tape, as well as witness statements from Robert White, Joshua White, Rebecca Johnson, Cassandra Campbell, Katie Cashman, Jonathan Cavalier, and Paul Amend, and Zach Corley.
And my only position with that is that I'm not seeing any exhibit list by number, unless I'm missing it, but I'm sure the city attorney and I could work together if she wants to do
Would you step up to the microphone and repeat that, please?
What I was just handed was a packet of stuff, discovery in this case. None of it's lettered as exhibits, so I don't know what that letter is referring to as far as an exhibit. So if the city attorney just wants to provide before the next hearing date a list, Exhibit A is this, Exhibit B is this, I'll be more than prepared on the next hearing.
I think
I can hand in my packet. Right now it's done. This is the council communication.
That's fine.
Did you have?
I was just going to inform Mr. Mendes, all of this material is available on our website, and the exhibits are listed there, so just for future reference.
I know there is information, but not all this information is available on the website. We've done that. But I have it all now, so I'll be ready to go.
Do we want to enter these now, or since we've continued the meeting, we should do it next time?
That's fine with me. I'll withdraw the motion. I think what's important is that everyone seems to know that we've exchanged the right information.
Okay. Thank you.
Thank you for your time.
So the motion is approved to continue this meeting. There are no further items on the agenda.
Well, Mr. Mendes, before you leave, it sounds to me like we would have more than 4 hours. Well, it sounds to me like we potentially could have more than 4 hours. Say we start at 6. I know our guidance from council is to try to be done by 10. Is there any appetite from the authority to set a second date now? Should the 28th take longer than we think is appropriate?
I would rather wait until the 28th to see how things move
I agree.
before we decide if there's to be another meeting. There may be more than 2 total hearings, and I wish to have a conversation privately with the prosecutor before that happens. But I'd just as soon wait until we get into that and do our. There's really not a time limit on how long a hearing can last. It's just a practical thing, and we're keeping police officers off the street, keeping people away from their homes. People tend to lose attention after a few hours of listening to testimony, and we don't want that to happen. We want rapt attention paid to the testimony. So I think I would prefer that we go as long as we need to go on the 28th, and then at that point we'll discuss a further another date for that.
Okay.
And for the city clerk, if you can provide us with guidance on that evening of what's acceptable for continuance, how long we can continue or extend the meeting. Do we have to come back within 10 days, or?
Yeah, I just want to clarify, Chairman Bradish, you had said have a conversation with the prosecutor, and I believe you meant you would receive advice from the city attorney as the counsel for the authority about how to schedule those special meetings and to continue beyond 1 or 2 or 3 hearings. And so
Okay.
I can work with you on that before the meeting on the 28th if it looks like we're going to need additional meetings.
Thank you very much. We'll see
Thank
you in
folks.
2 weeks.
Take care.
There being no further business before the authority, I'm
Mr. Chairman, could we have a staff report and see what's coming up in the next couple of weeks?
We do have 2 new liquor licenses that will be coming before you, but in discussion with the city attorney and the city prosecutor, we're thinking that we may want to bump those to the March hearing to free up the February hearing in case we have to continue this one to a second meeting.
at any rate, they wouldn't come up before the regular
They would come up,
February
they're
meeting.
scheduled for February right now, but neither one of their businesses are open or built yet, so if we push them out a month, it's
So if we need the February meeting for
correct.
continuing this, we can do that.
Have you asked them if they're okay with that? Because I wouldn't want to delay.
We haven't yet because we didn't know what was
Sure.
going to happen
Would you-
this evening. So
Absolutely.
Would you mind reaching out to them? And
Absolutely.
if they say no, then we'll figure out, I wouldn't want to delay it, because obviously this isn't, they have,
Absolutely.
this isn't their concern. So that makes sense, but if you would just reach out and ask them if that is acceptable to them.
And just for our general information, what's the identity of those establishments?
We have a new sushi and Japanese cuisine restaurant coming in over on South Federal Circle in the same strip center as Toad Tavern. And then we have a new retail liquor store coming in on Mineral and South Platte, over in the new construction over there.
Okay.
Platte River Drive or whatever. that-
Platte Canyon?
Platte Canyon, I'm sorry. Okay.
So, and I just want to let the authority know that I'm going to be gone for the March meeting. And so we will have a outside counsel here, Corey Hoffman, will be here covering for me. So I would prefer that we try to get through the show cause hearing before March so that we're not switching attorneys
We'll
in the
do
middle of
everything we
it.
can to make that happen.
Right.
I knew you were going to be gone, and I would very much like to have it all completed by then, believe me.
Okay.
And Mr. Chairman, for the record, I'm going to be on February 7th through 17th, so I will be here for the January 28th hearing, but if it continues past February 7th, it doesn't make me any sense for me to attend that hearing.
We'll take that into account if we have to reschedule.
Right.
As I was about to say, this meeting is adjourned.